Thank you for joining our webinar today entitled How Low Can You Go? On EEOC Final Regulations Implementing the ADAAA Amendments Act of 2008. We've titled the program in this way to reflect the significantly lower threshold on ADA coverage under the Act and the new EEOC regulations. My name is Brian Pedrow. I'm a partner in Ballard Spahr's Labor and Employment Group in Philadelphia, Pennsylvania.
My name is Bak-Boychuk. I'm an associate in the Ballard Spahr Labor and Employment Group in Philadelphia.
I'd like to thank everyone for joining us today. We trust you'll find the next hour informative. If you have questions during our presentation, you can submit them by typing in the lower right-hand corner in the window. Rather than taking questions during our limited time together, we'll review your questions after the program and then prepare a follow-up Q&A, which will be sent to all participants after the program's ended. Look at our agenda for the coming hour. We're going to review regulatory history of these regulations, and then we're going to move into 6 substantive areas where the changes have occurred. They are in the definition of substantial limits, MAFE activities, a list of disabilities that I call per se or virtual per se disabilities. We'll talk about mitigating measures, dormant or episodic impairments, and we'll talk about the regarded as prong of the definition of disability. And we'll conclude with a few employer action items that you should be thinking about in light of these changes. Turn to regulatory history. The ADAAA Amendments Act of 2008 was signed into law on September 25, 2008, amending the original ADAAA, which was passed back in 1990. The ADAAA Amendments Act, or the ADAAA, as it is sometimes called, took effect on January 1, 2009. The purposes of this legislation were generally fourfold. Congress was looking to confer the broad possible coverage of protected individuals, quote, to the maximum extent permitted, end quote, by the piece of legislation. Congress also intended that the determination whether an individual has a disability should not demand an extensive analysis, but in many cases should be a foregone conclusion. You'll see this principle reflected in the list of what I termed virtual per se disabilities. Congress also intended that the primary focus should be whether the employer has complied with its obligations, not whether the individual has a qualifying disability. In other words, the focus should be on reasonable accommodation and non-discrimination. Congress also intended to reverse a pair of Supreme Court rulings from 1999 and 2002. One of them, Sutton versus United Airlines, involving the mitigating measures concept. The other, Toyota Motor Manufacturing versus Williams, involving the substantially limits language. Turning to proposed regulations themselves, they were issued initially on September 23, 2009, followed by a 60-day comment period. The EEOC actually accepted some comments as late as December 15, 2009. The Commission received over 600 comments, and the EEOC and the Department of Justice, which enforces Titles 2 and 3 of the ADAAA, held a number of town hall listening sessions between October and November of 2009 in California, Chicago, New Orleans, and here in Philadelphia, where we are located. To the EEOC, some comments related to subjects outside the scope of the Americans with Disabilities Amendments Act touch issues like the definition of direct threat, regulations concerning association with disabled individuals, and the interactive accommodation process. The EEOC declined to make any changes in those areas. Regulations were then issued about 12 days ago on March 25th. They are effective May 24th, 2011. For the first I can recall, the EEOC, in publishing the final regulations, did not identify who the commenters were. Some merely saying employer groups or disability advocates. They seem to group together many of the comments, and as a result, the preamble to the new rules is very short, only about 6 pages in the Federal Register. The final regulations contain substantive changes to the ADAAA based on the Amendments Act in the 6 significant areas I mentioned earlier. The regulations reportedly reflect bipartisan agreement of all 5 of the commissioners on the EEOC. 3 Democrats and 2 Republicans. I had the benefit a couple of weeks ago of attending a lunch keynote address by Hy Feldblum, one of the Democrat commissioners, and Vicki Lipnick, one of the Republican commissioners, where they explained the process that they went to adopt the regulations and how hard they worked to try and form a bipartisan consensus. And as a result, they felt they issued a more balanced set of regulations. They were approved 5-0 by the Commission. I want to mention the Department of Justice's role here. As I mentioned earlier, the DOJ enforces Titles 2 and 3 of the ADAA. Title 1 is the employment title, and that's what we'll be talking about today. Title 2 covers state and local governments. Title 3 covers places of public accommodation. The ADA Amendments Act amended the definition of disability across all the titles of the ADA, not just in the employment arena. While the Department of Justice, on March 25th, the date the regulations were issued, to ask them whether or not DOJ planned to adopt the new regulations under Titles 2 and 3. And we were told that DOJ indeed did have input into the new regulations, and they did expect to adopt them, although they would not commit to a time frame beyond within a few months. Briefly on the regulatory impact statement that accompanied the issuance of the final regulations, they contain some interesting statistics. The first question that I was interested in seeing was how many people that have disabilities that will be substantially limiting now under the new regulations. The EOC estimates that at least 60 million Americans may be covered, or about 20% of the U.S. population, which currently stands at about 311 million. Of these, as many as 64% are in the labor force, which means that the EEOC estimates some 38.4 million Americans now will be covered by the ADA. That's about 12%, or 1 in 8. Number strikes me as quite low. I suspect the actual coverage figures will be much higher. Take, for example, the condition of hypertension. According to the American Heart Association, 74 million Americans above the age of 20, which would obviously encompass a lot of the workforce, have high blood pressure, and about 70% of those are seeking treatment for their high blood pressure. And according to EEOC, hypertension is now a covered disability even if it's medicated. So those alone say to me that the EEOC's estimated 38 million working Americans is too low a number. You add something like high cholesterol into the mix, which according to the CDC, the Centers for Disease Control, something like 17% or 52 million Americans have this impairment. Granted, there may be overlap between those with high cholesterol and those with hypertension. Nevertheless, you can see the numbers quickly reaching far in excess of 38 million people. More people with disabilities might be requesting reasonable accommodation, and I'm sure that's a question many employers are asking themselves. The EC estimates in their regulatory statement that some 6.1 million more labor force participants will seek a reasonable accommodation than before the passage of the Amendments Act. How much is this going to cost you might be another question you're asking. According to Job Accommodation Network, which is a free government service created with the ADA in 1990, the mean cost of an accommodation that had any cost was $1,183, although most accommodations, about 56%, actually cost nothing, according to the Job Accommodation Network. This also includes a couple of outliers where the accommodations cost exceeded $100,000. Use figure in eliminating those couple of outliers, the EEOC estimate the actual annual mean cost of an accommodation falls to around $715, and this in turn yields an annual incremental cost of compliance for reasonable accommodation in the range of $60 to $183 million. These costs, by the way, are exclusive of any administrative costs and legal costs associated with compliance, such as HR or managerial time to address requests for accommodation, work training, and litigation of claims. At the stage, let's turn our attention now to the substance of the new rules. First, the next slide gives you the definition of disability under the ADA. By this definition is unchanged by the Amendments Act. With an individual, the term disability means a physical or mental impairment that substantially limits one or more major life activities of the individual. The highlighted terms in red, substantially limits and major life activities, are areas where the ADA Amendments Act did make changes in the definitions of those terms. The second protected category is someone who has a record of an impairment, and the third is someone who is regarded as having an impairment. And again, regarded as is an area where we will see changes in the ADA Amendments Act. So let's turn our attention now to the substantially limits component of the definition, and Alex will explain that to you.
Thanks, Brian. Substantially limits. Despite many requests for a redefinition or even a clarification of the term substantially limits, the EOC did not change it out of concern that it would lead to, quote, confusion, end quote. Instead, the new regs just provide that substantially limits shall be construed broadly in favor of expansive coverage and to the maximum extent permitted by the law. So you ask yourselves, what does this mean? Well, the regulations tell us what it does not mean. If you compare the old definition that we have above the new one, you'll see that substantially limits does not mean significantly restricted. It also does not mean prevents or severely restricted as previously defined and strictly applied by the Supreme Court. The rules do give us 9 rules of construction that cover some of the concepts we'll talk about today, and that repeatedly state the idea that substantially limited is not meant to be a demanding standard. Ultimately, it's a pretty circular definition. All we know for certain now is that substantially limits invokes a standard of functional limitation that is less than the standard before the ADAAA Amendments Act. So how the word substantial been effectively removed from the statute? We'll have to see. So let's turn to the next slide and take a look at some concepts covered by the new regs that interpret substantially limits. First is most people. In order to determine whether a person has a substantially limiting impairment, the person's ability to perform a major life activity should be compared to that of most people in the general population. Before the Act, the comparison was with the average person in the general population. So does the change from average to most make a difference? According to the EOC, no. This is not a substantive change, but is meant just to conform the regulatory language to the legislative history of the ADA and to make the concept, according to the EOC, simpler and more straightforward. Condition, manner, and duration. There were many requests that the regulations continue to define substantially limits by reference to these terms, the way it was done before, and many employers think that these concepts are relevant in all cases. The EC took the position that these concepts are relevant in certain cases, but unnecessary in others. Condition, manner, or duration are now absent from the definition of substantially limited, but the regulations go on to say that it may be useful to consider these factors. The focus should be on how the major life activity is performed, taking into account conditions. So in other words, how difficult is it? Does the individual experience pain, fatigue, manner? In other words, how much effort does it take? How does it impact the major bodily function? And time. How long does it take? And then finally, statutory conditions. Before the Amendments Act, there was no specific duration to establish a substantial limitation, but we knew that pregnancy or 9 months was considered too temporary. We also knew that broken bones tended to be short in duration. But despite requests for specificity, the EOC said no, did not provide any minimum time that any impairment's effects must last. And this is consistent with the Act's intent that an impairment's duration is only one factor in the substantially limits analysis that may be useful. The EOC also removed from the final regulations a limited list of impairments that usually are not disabilities because they are non-chronic and just too short. So these are impairments like the common cold, seasonal flu, your strained joints, and your broken bones. The EOC removed these impairments due to the, again, quote, confusion, end quote, they created. This is major. Short-lasting impairments can now be substantially limiting if they're sufficiently severe. And by short-lasting, that can be 6 months or less. So what does this mean for our traditional understanding about temporary impairments? Is pregnancy with severe morning sickness now going to be covered? Broken leg that's in a cast for 12 weeks, followed by 12 weeks of physical therapy. EOC gives an example of an individual who has a 20-pound lifting restriction that lasts or is expected to last for, quote, several months, quote. According to EOC, this individual is disabled on the ADA. And pregnancy, the EOC tells us that it ordinarily will not be covered under the ADA because it's not a physiological disorder. But take a pregnancy-related impairment like gestational diabetes. This substantially limits a major life activity or a major bodily function and may now be covered. Okay, if you perked up your ears at the phrase major bodily function, Braun will now explain how this new term fits with a broader definition of major life activities.
Okay, major life activities. We have the old EEOC definition with those basic activities that the average person in the general population can perform with little or no difficulty, including functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. And we were told, of course, that this is a non-exhaustive list. The EEOC definition of major life activities made some significant changes. First, expanded this traditional non-exhaustive list of major life activities and added a new non-exhaustive list of major bodily functions, or MBFs. Also removed the requirement that the activity be one which the average person in the general population can perform, and it clarified that only one major life activity or major bodily function is needed to be substantially limited. Average person, the removal of the average person requirement. The regulations relaxed the definition of major life activity or lowered the bar further by removing this requirement. The EEOC initially in the proposed rules had proposed changing the language to activity that most people in the population can perform with little or no difficulty. They then eliminated that qualifier as well in the final rules. Whether activity is one which most people in the population can perform with little or no difficulty may still be relevant to the determination whether it is substantially limiting, but will not be relevant to whether it qualifies as a major life activity. The word major. The regulations state that the use of the word major shall not be interpreted strictly to create a demanding standard for disability. It does not mean, for example, that activity is of central importance to one's daily life. The C gives examples of life activities that would be covered by the ADA even if the task is not of central importance to one's daily life. For example, lifting, fine motor coordination, grabbing, hand strength, or grip pressure. So the word major virtually seems to have no meaning at this point under the ADA. This is similar to how the word serious had been literally read out of the FMLA's definition of a serious health condition. Recall how the Department of Labor decided the FMLA could cover conditions like common colds and flus if they otherwise meet the definition of a serious health condition. As Alice just explained, the EEOC seems to have taken a similar approach with respect to certain common ailments under the definition of disability. There's an expanded list of major life activities. On this slide, you see on the left-hand side in black the traditional list of major life activities. The EEOC has now expanded that list. It still is a non-exhaustive list, but now we have a list of additional activities in red on the right-hand side: eating, sleeping, standing, sitting, bending, reaching, lifting, reading, concentrating, thinking, communicating, and acting with others. Some of the comments the EEOC received urged an even more expansive non-exhaustive list that would have included things like typing, keyboarding, writing, driving, having sex, squatting, getting around one's house, farming, ranching, composting, operating watercrafts, and maintaining an independent septic tank. These were all submitted by commenters asking for a more expansive definition of major life activities. The EEOC, however, felt it unnecessary to include these because many of these activities may or may not be major life activities, or more importantly, may be part of other major life activities, or the fact may be that the individual cannot do the activity. Who not do such an activity may otherwise be substantially limited in a different major life activity. We have a definition of major bodily functions. This is a big expansion of the major life activity definition. We have a list now of a number of major bodily functions which, if substantially limited, will trigger ADA protection. Things like immune system, that would cover something like HIV infection, special sense organs and skin, normal cell growth, which may be substantially limited due to cancer, logical function, which may be limited due to Parkinson's disease, for example, diabetes impacting the endocrine system, sickle cell impacting the hemic system, and so on. The conditions listed in red are ones that did not appear in the proposed regulations, but were added subsequently in the final regulations. The regulations also clarify that the operation of a major bodily function can include the operation of a single organ within the body system, not necessarily the entire system. Musculoskeletal is one that certainly caught my attention. That adds considerable breadth to the scope of ADA covered impairments, in particular impairments that may be difficult to disprove, engaging workforce in America today, and problems that are associated with back, neck, and joints. I'd like to talk for a moment about working. The EEOC removed from the ADA regulations of working as a major life activity, except maintaining a general reference to working as being one of the types of major life activities. This discussion about working was now moved into an interpretive appendix that accompanies the regulations because, according to the EEOC, working does not require special explanation, and given the expanded definition of the substantially limits and major life activities terms, working will only be used in, quote, very targeted situations, end quote. In the majority of cases, the individual is going to be relying on some major life activity other than working. In case where working is the major life activity in question, the individual still must show that the impairment substantially limits his or her ability to perform a class of jobs or a broad range of jobs in various classes as compared to most people having comparable training, skills, and abilities. This is the standard that existed before the ADA Amendments Act. What it means is that there will be far less debate about whether an individual is substantially limited in their ability to work in order to be covered by the ADA. The focus instead is going to be on other major life activities, which are easier to prove. To give a couple of examples of cases in which the courts before the ADA Amendments Act had found somebody not to be substantially limited in major life activity, which are very likely to come out differently today. There was a Seventh Circuit decision from 2001 where cirrhosis of the liver caused by hepatitis B was held not to be substantially limiting because liver function is not central to one's daily existence, like eating, working, or reproducing might be. There, clearly, we now have a substantial limitation of organ function which would be covered. In a decision from New Hampshire in 2002, stage 3 breast cancer was held not to be substantially limiting of an individual's ability to care for herself, sleep, or concentrate. Now, we undeniably would have a substantial limitation of the cell growth due to cancer. In another case, an individual with cerebral palsy who could not perform certain specified manual tasks was not substantially limited in her ability to perform a broad range of tasks and thus was not protected by the ADA. We would never even get into that inquiry anymore because there would be no question that cerebral palsy essentially limited her in the area of brain function. You mentioned earlier today that there are some disabilities that the EEOC has now classed as virtual per se disabilities, and Alex is going to walk you through that section of the new regulations.
So the new regulations still require an individualized assessment of whether a person's impairment substantially limits a major life activity. But Brian mentioned the regs now contain a section called predictable assessments. We call this the virtually always section. What does this mean? All of the impairments listed in this section, given their inherent nature, will, quote, virtually always, end quote, be substantially limiting, and no individualized assessment is needed. Understandably, commenting employers were not too happy about this. What virtually always means is that employers have virtually no right to question whether someone with any of these conditions has a covered disability. Remember, the EEOC removed from the final regs that list of impairments that are usually not disabilities, the broken bones, the common cold, the dislocated joint. Well, the removal of the usually not disability, together with the insertion of these usually are disabilities, is yet another signal of just how broad coverage has become under the law. So let's take a closer look at some of these per se disabilities. Some of these impairments, like deafness, blindness, partially or completely missing limbs, these have outward physical manifestations, so they present less of a challenge to employers in the analysis. But there are others that impact such functions as thinking, concentrating, or interacting with others, and they're not as easy to observe. So take autism, for instance. It substantially limits brain function, but it's not easily susceptible to diagnosis. Then diabetes substantially limits the endocrine function, but can be controlled by medications, and someone with diabetes may appear highly functioning in the workplace. Then there's HIV infection. Substantially limits the immune function, but can remain asymptomatic for a long period of time. Then we have the last 5 disorders in schizophrenia, or the last 4 disorders in schizophrenia: major depressive disorder, bipolar disorder, post-traumatic stress, and obsessive compulsive disorder. These substantially limit brain function, so again, no outward manifestation. And here's the tricky thing. The regs exclude poor judgment or quick temper as impairments. So one of your employees may have a personality trait that's not covered by the ADA. Another one can appear to suffer from the same trait, which is in fact a symptom of a major limitation of brain function that is now virtually always a disability. Remember, too, that working is only one of the major life activities, like Brian just talked about. So any of these individuals could appear to have no problem working and even excel at the job because of his or her limitation. He or she is now pretty much automatically protected as a disabled individual. This is really important when this person now approaches you for a reasonable accommodation. It also becomes important when there's a discrimination claim that an adverse action was taken against him or her because of the disability. Now, I mentioned before the medications that the diabetic takes to function in the workplace. Under the final regs, these meds are now one of the mitigating measures that employers cannot take into account in the substantially limiting analysis. Brian will tell you some more about that right now.
Okay, mitigating measures. The new EOC regulations provide that the determination of whether an impairment is substantially limiting shall be made without regard to the ameliorative effects of mitigating measures. The exception to this is ordinary eyeglasses or contact lenses. So what are the kinds of mitigating measures we're talking about? Well, medication is a major category. So we're talking about prosthetics, including limbs and devices, hearing aids or hearing implants, mobility devices, assistive technology, any form of reasonable accommodation that constitutes an auxiliary aid or service. In addition, we're talking about learned behavioral or adaptive neurological modifications. And then the final regulations added the last category, therapy, behavioral therapy, or physical therapy. What it means is that all of these types of mitigating measures will no longer be considered in making the determination whether or not someone is substantially limited in a major life activity. This, for example, that hypertension, which may be fully controlled through medication, now is covered by the ADA because in the absence of the medication, the individual's major bodily systems, be it cardiovascular and or circulatory, would be substantially limited. The EOC used that very example in its interpretive appendix. This means that a leg amputee who has a prosthetic device and is capable of running a marathon is not substantially limited in a major life activity because you would measure the limitation without the device. A couple additional points that I'd like to make about mitigating measures. One is a question of surgical interventions. In the proposed regulations, the EEOC had included on its list of mitigating measures that cannot be considered surgical interventions except for those that permanently eliminate an impairment. In response to comments, this was removed from the list. The EEOC felt that it was better assessed on a case-by-case basis. Therefore, it's unclear today what the EEOC's position is on surgical interventions that wholly or partially ameliorate the effects of an impairment. It seems that a surgical intervention that totally eliminates the impairment ought to be taken into account when doing the substantially limits analysis. For example, a torn rotator cuff, which if unrepaired would be substantially limiting, but no longer is after surgery. Covered, not covered, we're not sure. The ameliorative effects of mitigating measures is also worth exploring. While we can no longer consider the ameliorative effects of mitigating measures, the ADAAA regulations instruct they must take into account the non-ameliorative effects of mitigating measures when we're evaluating the condition, manner, and duration of an impairment to determine if it's substantially limiting. This means considering things like negative side effects of medication, burdens associated with a treatment regimen, or complications arising from surgery. So the corrective impact of a mitigating measure cannot be considered. The negative impact of a mitigating measure must be considered. The individual refuses to use a mitigating measure. This is a question that often arises in the context of a reasonable accommodation dialogue. This is irrelevant for purpose of the substantially limiting analysis. According to the EEOC, someone's refusal to use a mitigating measure has no bearing on whether the person is substantially limited in a major life activity. The decision not to use a mitigating measure, such as a medication or a proffer reasonable accommodation, may have an impact on whether the individual is qualified or poses a direct threat in the workplace. That is according to the EEOC in its interpretive appendix accompanying the final rules. To give you a couple of examples of cases that would come out differently today than just a few years ago before the ADAAA Amendments Act was passed. The Wyoming decision in 2004 where an employee was claiming that he had been terminated because of clinical depression. The court, the employee was not protected because the condition was fully managed with medication for over 15 years. Similarly, in a New Jersey decision in 2003, a hearing-impaired employee claiming to have been fired based on disability was held not to be protected because a hearing aid had fully corrected the impairment. Clearly, these cases would turn differently on the threshold inquiry of whether or not the person has a disability given the new regulations. Let's talk now about dormant or episodic impairments. Alex?
Act covers impairments that are dormant or episodic. Comment stage, employers requested some clarification of these terms to eliminate from coverage progressive impairments such as Parkinson's disease on the ground that they would not be disability in the early stages. But EEOC declined to make this revision because major bodily functions, as we've now described, are themselves major life activities, and even early stage diseases like Parkinson's can substantially limit brain or neurological functions. The regs now provide that an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. So what impairments is this meant to capture? Hypertension, diabetes, asthma, major depressive disorder, bipolar disorder, schizophrenia, post-traumatic stress disorder. Interpretive appendix shows us just how differently already decided cases might come out today. So, for instance, the Southern District of Texas had determined that epilepsy, which resulted in short seizures during which the plaintiff was unable to speak and experienced tremors, was not a disability. Now it's covered, and this decision today will likely come out differently. There's another decision coming out of New Hampshire where a court determined that an impairment like cancer in remission was not a disability. Today, it is. This is a big deal, particularly with hypertension, like we've already touched on. There are an estimated 75 million Americans dealing with high blood pressure that are over the age of 20. So these are people in your workforce. About 70% of them are seeking treatment for hypertension. Again, a major expansion of coverage under the broader definition of disability. And with that, I'll turn this over to Brian, who will cover the changes to the regarded as prong.
Earlier, the third prong of the definition of disability, regarded as, also underwent a significant revision in the ADAAA Amendments Act and the final regulations. EEOC regulations, they define regarded as meaning that the individual has been subjected to an action prohibited by the ADA because of an actual or perceived impairment, not both transitory and minor. One of the key changes under the ADAAA Amendments Act is that the regarded as prong, like the other two prongs of the definition of disability, an actual disability or a record of a disability, as no longer requires showing that the impairment substantially limits a major life activity, which will make it much easier for an individual to show that they were regarded as disabled. The ADAAA amendment regulations also clarify that there's no obligation to provide reasonable accommodation under this prong, and for the reason the EEOC noted that where an individual is not seeking a reasonable accommodation, the case usually will proceed under the regarded as prong, not actual disability or record of prongs of the definition. What it means is that in the traditional discrimination case where someone's not claiming denial of accommodation, but rather that they're claiming they've been discriminated against on the basis of a disability, the case is very likely to proceed as a regarded as case. A couple additional points about regarded as. The concept of transitory and minor, or what is sometimes called the transitory and minor defense. There's no definition of minor in the new regulations. Transitory, however, is defined as lasting or expected to last 6 months or less, and will be based on an objective standard. To establish the defense of the impairment being transitory and minor, it has shown that both it is transitory and minor, not just one or the other. Both criteria must be proven. The regulations had included 2 examples of transitory and minor conditions that would not qualify under the regarded as prong. These, fortunately, were removed in the final regulations because the EEOC felt the need to, quote, streamline the text of the final rule, end quote. These examples were first a broken leg that heals normally, a sprained wrist that limits the ability to type for 3 weeks. Some others felt that while these conditions are transitory, they should not be categorized as minor, and therefore they should fall outside of the transitory and minor defense. The EEOC, apparently agreeing with those comments, removed them from the final regulations. Does the definition of transitory apply to the first prong of ADA protection, an actual disability? The answer is no. The regulations make it clear that the transitory nature, the transitory definition for regarded as, has no application to other 2 prongs of the definition. That means that we do not have a bright line 6-month rule for how long a condition must last to be substantially limiting. And the EEOC specifically said that short-term but severe impairments may in fact qualify as substantially limiting, even though they would not qualify under the regarded as definition. Protection and causation. The ADAAA regulations clarify that an individual may not be subjected to a prohibited action because of an actual or perceived impairment, regardless whether the impairment substantially limits or is perceived to substantially limit the major life activity. Actions are the things that we typically think of in the employment arena under civil rights laws: the refusal to hire, a demotion, placement on involuntary leave, termination, exclusion for failure to meet a qualification standard, harassment, or denial of any other term, condition, or privilege of employment. They are all considered prohibited actions. Merely being regarded as impaired does not establish liability, however. The individual still must prove that he or she was discriminated against on the basis of or because of the disability. The EEOC gives us some examples of prohibited actions in the interpretive appendix that would trigger liability under the regarded as prong. Terminating an employee because he has cancer, refuse to hire an employee because she has skin graft scars, terminate an employee from working around machinery because he has angina. Again, however, that may trigger a direct threat defense and does still remain available to the employer. We turn now to some employer action items in light of the changes brought about by the ADAAA Amendments Act and the final EEOC regulations. First, for ADA policy, if you have an ADA policy, it should be reviewed to determine if it's compliant with the new definitions. If you don't have an ADA policy, this may be a good time to consider adopting one so that you can set forth what is expected of employees if and when they are in need of accommodation. With expected increase in ADA requests for accommodation, it is probably now more important than ever to have in place a clear policy and procedure advising employees of their responsibilities when seeking an accommodation. Training. It's imperative that your human resources personnel and your supervisors and managers understand the new expansive reach of the American Americans with Disabilities Act under these rules. Remember, as many as 1 in 8 of your employees may now be protected by this law. Supervisory training that addresses the scope of the ADA and how to respond to employees who need or seek an accommodation is important. Courts have upheld punitive damage awards against employers who failed to train their supervisors because of what has been termed a failure to educate employees, and in particular supervisors and managers, on the requirements of the ADA. If you use ADA medical questionnaires to explore whether or not an employee needs an accommodation and in fact has a qualifying disability under the ADA, it is certainly time to update those questionnaires to make sure that you are seeking input based on the new definition of what is a qualifying disability. You will also need to be more cautious about when you're going to use a medical questionnaire, particularly in those cases of virtual per se disabilities. The EEOC cautions that it may not be necessary in all cases, and in particular those cases, to even make an inquiry whether somebody has a qualifying disability. It should be presumed under many circumstances. Find your statements of essential job functions, whether they exist in job descriptions or they exist in separate standalone documents. It didn't update your statements of essential functions when the FMLA regulations were amended. This is a task that should definitely be put back on your to-do list for 2011 in light of the amended ADA regulations. And with the expected increase in requests for accommodations, now what are essential functions would not be modifying or compromising in the accommodation process from marginal functions. Things you may need to consider modifying are going to be particularly important. That's the presentation for you today. I'd like to thank everybody for joining us. Again, we look forward to reviewing any questions that you may have as a result of our presentation, and we will issue a Q&A in the program.
Everyone.